Good evening, everybody. I'd like to call this meeting to order at 5:01 on Tuesday, July 27th, 2021. And the first order of business is the Pledge of Allegiance to the flag. Will you please join me? Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everybody. We have two school board members joining us on Teams, Mrs. Barenborg and Mrs. Rosario. And so if you see some faces cropping up from time to time, you'll either recognize them or know who they are. The first order of business is the adoption of the order of the day. Are there any items board members wish to move from consent to action?
Mr. Chair, just a point of clarity regarding item 4C. There is no employee being recommended for termination this evening. This item seeks approval to assign a hearing to an administrative law judge based on a request from an employee, no termination being made. Following that hearing, a recommendation will come back before this board for final action. Is there anything?
So can I have a motion to approve the orders of the day?
So moved. Second.
I'll second.
All in favor? Aye. Opposed?
Aye.
Thank you. Motion carries 5-0. The next item is citizen input. And I will read the rules, the guidelines. Each statement made by a member of the public shall be limited to 3 minutes duration. Persons will be recognized in the order in which the requests were received. The time shall start when the speaker is at the podium, and the school board attorney will be the official timekeeper. You will hear a beep at the end of your 3 minutes. Persons may speak for up to 3 minutes at the beginning of a business meeting during citizen input as indicated on the order of business, and for up to 3 minutes to each action item during the action agenda and each board member discussion item as indicated on the order of business. Persons may only speak once about any given item. The time period may be extended by the presiding officer. Only the individual submitting a speaker's form is allowed to address the board. Time may not be yielded to other speakers. During the meeting, please refrain from clapping or outbursts of any sort so that we can proceed with dignity and with decorum by not infringing on any individual's First Amendment rights. I need to remind everyone to direct all comments to the chair, not to individual board members or the superintendent. Board members may or may not address any citizen input statement at the end of the citizen input comments. As board members listen to citizens without interruption, citizens are asked to give board members the same respect. So, without further ado, the first we have, there's one request here to speak to item 4C. That is not, that's not something that will be addressed during citizens' input. As Dr. Moore just explained, there was perhaps a misunderstanding or miscommunication on exactly the title of item 4C. Dr. Moore's explained what will proceed, so we will not be discussing any of that this evening.
Mr. Barenborg, excuse me, I apologize for interrupting. If the individual was speaking to that agenda item for something other than the factual basis of the recommended termination, the individual would be allowed to speak. The issue that we're dealing with here is we want to protect the employee's due process rights. The employee has requested a hearing, an administrative hearing, to have an evidentiary hearing so that facts and evidence can be presented to a hearing officer. All of that has to happen at the evidentiary hearing, so we can't have facts and evidence presented to this board this evening. Once the hearing officer concludes the hearing officer will come up with a recommendation. That recommendation will be brought back to the school board, and then the school board will essentially be sitting as the judge at that later meeting to make a final decision about any recommendation from the hearing officer. So I just want to be clear, your statements are correct, that we should not be speaking about the evidence, the underlying basis, the facts, the evidence, the witnesses tonight. That's not appropriate for this public comment section, but if someone had a comment that was outside that, we certainly want to allow them the opportunity to say so. So with that clarification, if the first individual had something outside the facts or underlying basis for the recommendation for termination, they should be allowed to speak if they wanted to talk about a process that had nothing to do with the underlying facts of the recommendation.
I get it. So there's one person that wanted to speak, and that's Mr. Broad. If you care to speak in the manner in which Mrs. DeAgresta just outlined, that's the only person that asked to speak to item 4C. So if you want to, fine.
Hello, my name is Michael Browd. I am a teacher at Heritage High School in Palm Bay. In regards to item 4C, I would like to propose that we have a public comment in regards to that. Thank you.
All right, the first speaker is Jamie Sturgeon.
Good evening, everyone. I'm Jamie Sturgeon. I'm IB coordinator, AP coordinator, guidance counselor at Splash River High School. And I did come down to talk about what was going to be happening, I guess, with 4C. And I'm glad to see that it's going to be going in front of a hearing board. To speak about Garrett, I've known him for many, many, many years, even as a student when he came through Sebastian River Middle School. He's a great man. He's a great teacher.
Excuse me, Mr. Bearberg, I'm sorry. Character witnesses, that sort of information to be presented to the hearing officer, and this board will hear the recommendation from the hearing officer. So character witnesses, that character testimony with regard to the matter should be to the hearing officer, not this board.
Okay, so are we allowed to go to the hearing?
Yes.
How does that work? Does that hearing here, local? How does that work?
His 3 minutes are ticking, so
All right, my understanding is that, yes, you're allowed to go to that hearing and speak.
Do we know where that hearing is? Is it
not
here
to-
local?
How the process works.
I don't know the answer to that.
should I stop his?
Oh, it's okay. I
Yeah,
don't mind.
stop
Yeah, sure.
stop the clock.
Okay. If the board passes the consent agenda item that's before you this evening, you've not actually voted on it yet, but if you pass the consent agenda item as worded, tomorrow this matter will be referred to the Division of Administrative Hearings, which is an agency in Tallahassee, and that agency will assign an administrative law judge, a hearing officer. That hearing officer is required to set the hearing date and time and location within 60 days. So at some point later this week or perhaps next week, that hearing date, time, and location will be established. At that time, the legal counsel for the employee and the legal counsel for the superintendent will establish what evidence, what witnesses, what information should be presented on behalf of their clients to the administrative law judge. Whether this individual is selected as a witness, I can't speak for the lawyer who has to make that decision. But any type of character witnesses or character evidence with regard to the employee will need to be presented to the hearing officer. At the conclusion of that evidentiary hearing, the hearing officer will prepare something called a recommended order. That recommended order will summarize the testimony of witnesses. The hearing officer will weigh the credibility of the testimony of those witnesses, will review written evidence that's presented, and will come up with conclusions of law, and will make a recommendation back to the school board about the ultimate question of the recommended termination. Whatever that document is will come back to this board. at a meeting similar to this, and you will then review that recommended order. You will review the underlying evidence that the hearing officer entered into evidence, and then you, the board, will make a final decision with regard to the recommended termination based on the recommendation from that hearing officer.
Question.
Yes, sir.
So if Mr. Sturgeon or anyone else, obviously they're free to go to that hearing with the administrative judge, but once that recommendation comes back, if we're to make the decision based on that recommendation, accept it or not accept it or modify it or what the options would be, is the public allowed to speak to us, or at that point in time they can speak again before a decision's rendered?
At that point, the school board will be sitting in their quasi-judicial capacity, which means you'll be sitting as the judge, a 5-member judge, to make the final decision. Your decision must be based upon the testimony and the evidence presented at the hearing. You may, if you wish, receive public comment, but the law that mandates that we hear public comment at every other school board meeting on matters of business says specifically that when the school board is acting as its quasi-judicial capacity, there is no legal obligation to receive public comment. You may if you wish, but you must remember that any decision that you make down the road on that recommended order from the administrative law judge must be based on the testimony and evidence presented at that hearing, and that is found to be factual and correct by that administrative law judge. A simple analogy, I don't want to speak about this case, but a simple analogy is if a hearing went to an administrative law judge and the administrative law judge listened to all the testimony, and the conclusion at the end of the hearing was that it was a sunny day with no rain. When that recommended order comes back to the school board, if there is no other evidence that contradicts it was a sunny day with no rain, you can't change that conclusion. So it depends upon the findings and conclusions in the recommended order that will come back to us from the administrative law judge.
Go ahead,
You still have time, so
Don't worry
I don't
about
wanna
it.
lose track of that.
I'm having fun.
If you have, let's make sure that we're clear on this, because it's not your everyday.
Right.
Correct. You do not do this every day.
Thank goodness.
So questions for clarification.
Of course.
When that evidentiary hearing recommendation comes back to us, we cannot change the fact it's a sunny day with no rain. We can, however, choose to accept or not accept the recommendation of the hearing judge. Is that correct?
And my best answer is going to be maybe. What the law provides is when a recommended order comes back to the board, if the board wishes to revise the conclusions of law, you can only revise conclusions of law over which you have jurisdiction or interpretation authority. So the best example of that is if the administrative law judge makes a conclusion about one of your school board policies, and you know your policies, you've been implementing them for years, but the administrative law judge interprets it differently, you can change that conclusion because that's your school board policy, how you've interpreted for years, so you can change any conclusion that deviates from your past practice or your past interpretation of your school board policy, right? So that's an example of a conclusion of law that you would be able to revise. You can only revise an ultimate recommendation, decide the matter this way. If you wish to revise that ultimate recommendation from the hearing officer, the school board may, if it wishes, it must review all of the transcript of the entire hearing, all of the evidence and testimony, and then in making any change to that ultimate recommendation, you have to then go back and reference the pieces of the transcript or the pieces of the record that support what you desire to be the ultimate outcome. So you can't, I'm going to say maybe, because you have to go through the process and then have that discussion articulate specifically what in the record is allowing us to change that ultimate recommendation.
Okay. Question 2.
Yes,
You said the school board may elect to hear public comment when the hearing officer's recommendation comes back before the board.
yes.
How do we make that decision? Do we do it tonight as a board? Do we do this sometime in the future? Because we can't talk outside of this setting, so if we're gonna make a decision and an agreement as a board as to what public comment we'll hear, we have to do that here. Do we do that tonight? Do we do that at a meeting in the future? Do we do that when it goes to the hearing officer? How does that work?
Of course. My typical recommendation is when we know that the evidentiary hearing has been concluded, and we know that the hearing officer is in the process of preparing his recommended order, because I don't know when that's going to happen. When we are in that time frame, the board can then discuss, here is our process for the next steps. When the recommended order comes back to the board, here's what we're going to do. And the board can absolutely discuss that, how you wish to handle it. You can do it in a workshop setting. You can do it during one of your school board discussion sessions. So there will be a space, if you will, for the board to decide when the recommended order comes back to the board for final decision, here is the process that we will follow. Because there are some other pieces that may or may not come up. I just have no idea what may come up. Once a hearing officer issues a recommended order, both parties, the employees side and the superintendent side, have the ability to do something called exceptions to the record. So either side, or both sides, quite frankly, could file a document with the school board saying, I object to findings of fact 5 through 10 because it doesn't reflect what's in the transcript, and they cite to the transcript. Or I object to conclusion of law 15 because of some case that doesn't agree with that. So they have the opportunity to object to all of that. All of those exceptions are also something that the school board must rule upon during your hearing or your board meeting when you make your final order decision. So there may be several things that we need to handle during that board meeting. We won't know what we have to handle till we get there, but that's the process that we would just lay out to be sure that the board understands we're going to do this first, then we're going to do that, and number 3, number 4, number 5.
Okay. Point of clarification, I know you have
Oh, that's okay,
questions too. Is there so we only meet every 2 weeks, and depending on when that comes back, it may be every 4 weeks. Is there, once that recommendation comes back, is there a time frame within which we have to respond? If it doesn't fall at a time when we have a meeting prior to making the decision about what we will and won't allow, do we have to call a special meeting specifically for that? Or can we or the superintendent determine when that hearing officer's recommendation will come back before the board in order to allow time for us to come together to make the decisions you're referencing?
Yes, there is a time deadline. It's either 60 or 90 days.
Okay.
At the moment, I'm not remembering the it's by statute, so whatever the statute says we do. But if for some reason this board, for whatever reason, it falls in a period of time and you don't have a meeting, then trust me, I will be in touch. And we will need to schedule a specially set meeting just simply to address this. If there isn't another meeting that we can add it to, that's already
Okay, got it.
scheduled.
Thank you.
Of course.
Dr. Jones?
Obviously, people are here tonight because they looked at the agenda and saw that was approval to terminate. So with Mr. Sturgeon standing up there and not wanting to violate anything for any due process,
Right.
what can they say?
If there was a question about the process, which I have just blathered on and on about for quite a long time, if there was some other question, I mean, I never want to say to anyone, you can't speak at public comment. There are some topics that we should not be discussing this evening, but there may be other things that people wish to say or ask a question about that doesn't go into the realm of the underlying evidentiary basis for the recommended termination. So I don't want to put a limit on what people can talk about other than please don't talk about the issues that need to be heard by the hearing officer.
And that means also character.
Character witnesses, that would be something that would be heard by the hearing officer. And that individual would weigh the evidence presented to them and make a recommendation back to this board.
It sounds to me as if bottom line is, this is not something to be discussed tonight. This
The
is something
facts.
to let the hearing be scheduled, time, date, place. Between now and whenever that hearing takes place, we can always have an agenda item where we can discuss the process that we're going to use
Yes, sir.
once that recommendation comes back from the hearing judge. And then, when it does come back, the public can speak that night, correct?
If we so decide.
If we so,
if-
that's part of the process that we will
Yes, if the
decide.
board decides to allow for
All right.
public comment on a quasi-judicial matter. Yes, sir.
Okay. Dr. Jones, you
No, I
would.
was just going to say, we allow public comment on everything, it seems like. So I think it'd be unfair if we didn't allow it,
And what, allow
when
what?
we're supposed to allow it.
Right,
Well-
but I think what Mr. Gresta is saying, whether or not, is that we make that decision once we get the recommendation,
Correct,
rather than
right.
making it now.
Absolutely.
Because things may happen between now and then of which we're
Agreed.
not aware.
I agree.
And may I give one example of when the board has not allowed for public comment? And that's during a collective bargaining impasse hearing, which is also considered a quasi-judicial hearing, where the board sits as the quasi-judicial hearing officer. And the last few that this school board, not this iteration of the school board, but this school board has held, public comment was not allowed. We heard from the parties, no specific public comment, and then the board made its decision.
Thank you.
Well, and we don't entertain public comment when we're in pending litigation, just to clarify. We can, but we've made the decision in the past, when there is pending litigation, we don't discuss it in board meetings while that litigation is ongoing.
Yes, ma'am. Yes, ma'am. But
That's, which is not dissimilar from this process at the moment,
But
correct?
the board can absolutely make that decision, whether to allow public comment or not.
This is basically a three-step process. The first step is to, what we're going to vote on as part of consent is to, it goes to administrative law judge. Step two is we can discuss the process that we want to entertain, and step
Yes,
three
sir.
is when it comes back, we then follow that process before making a final decision based on the recommendation, correct?
Yes, sir.
And we can
All right.
place, at the will of the board, we can place a item on the next board workshop to define what that process is. So whether it's 30 days, 60 days, or 90 days, everyone in the community is clear in understanding what the process that this board will follow once that information is returned to us.
I think in fairness to everybody, that this be, I don't know whether expedite is the right word, but no one wants to have whatever is come out of this hanging out there. It's not fair
Absolutely not.
to the individual, it's not, and his or her friends, supporters, or the district who is the one that's recommending termination. So we should, the next scheduled meeting, which I think is August 28th, we should put it in the workshop for that day,
Understood.
all right? So, you got your money's worth tonight,
I got
Mr.
10 minutes,
Sturgeon.
yeah, that's good. All right, no, I appreciate that, and then I won't speak anymore, because obviously I'd be more of a character
IB
witness.
scores?
What's that?
IB scores, maybe?
Oh, IB scores, yeah, I could tell you about those real quick. We did very, very well. We had an 84% pass rate for our students, which was fantastic. Out of all the exams we took, I think it was about 350 exams, we passed 88% of them. So it was really good. We really had a good showing from our students in very difficult time, very difficult year. So congratulations to the students, congratulations to the teachers and the whole community, because they really worked hard, and very, very proud of them. And I must say that on July 5th, I was dancing big time. So thank you. I won't
Thank you,
say any
Mr.
more about
Sturgeon.
Garrett, but he's awesome.
Before we call the next speaker, I want to make sure that Mrs. Berenborg or Mrs. Rosario don't have a question or a comment, since the three of us have been interacting here with Ms. DiAgresta. Is everything?
Hi.
Go ahead.
Mr. Barefoot, hi, this is Mrs. Rosario. Thank you. I did have a question. And I apologize if this was stated earlier. This question is for Mrs. DiAgresta. I may have missed it in translation or, over audio. Is there a policy, do we have a school board policy that describes the process in which you talked about? Or is this based on statute?
Mrs. Rosario, this is really based on statutory requirements, both under the Education Code with regard to the recommended termination of an instructional employee, as well as the statutory requirements under the Administrative Procedures Act for an administrative hearing.
Okay, all right, thank you very much.
Mrs. Berenberg, are you okay? You look comfortable. Okay.
Can I add one thing, Mr.
Sure.
Burford? Just a quick, just to address everybody who's here tonight, I am sorry about the confusion, and I'm sorry about how this was put on the agenda in a way that brought confusion rather than limited it. That's all I'll say about it for now. So I'm sorry about that to all of you who took the time to show up tonight.
So I don't know how many of the other requests here, of which there are 16, really wanted to speak to this. Mr. Nunn, you're up next.
My name's Christopher Nunn, live in Sebastian, Florida. I'm here as a parent tonight. And my concern is, are you saying, and I apologize because the question is really for the attorney, but are you saying the process listed in the charging letter is not the actual process used? Because the process in the charging letter says that once you guys vote on this and say yes, Mr. Rue is terminated, and that the meeting, the administrative hearing, is to appeal the process. Now, that's what this reads, and I've learned, being up on the other side of that board, that what this says and what you vote on is what matters, not what's said by everybody else. So my concern is, are you saying what's in the charging letter? I read it very carefully, about 10 times. It says simply that once you say yes, Mr. Rue is terminated, and that this goes to an administrative hearing, an appeal hearing. You can't appeal a decision that's not been made. So are you saying that process? I mean, can we get clarification? Because that says different than what was just explained to us. Is it possible, Mr. Barefoot, to get that explanation?
It sounds confusing to me, I think probably to
Very.
all of us. Ms. DeAgresta, can you,
Am I
Help them out.
stopping the 3 minutes?
we can stop the 3 minutes. I think we really want to get this right. We want everybody to leave here, it fully understands exactly the process and what's going to happen.
Thank you.
The charging letter is quite clear. It advises the employee that they have a right to a hearing to challenge/appeal your termination. So if the employee wishes to challenge their termination, which I believe they do, it says if you wish to challenge your termination, then you must make a written request for a hearing, and it gives information of the date and time of the deadline and the location where it's to be delivered. If you timely request a hearing in writing, a hearing will be held.
I think that what Mr. Nunn is questioning is what comes first here, the cart or the horse. It sounds as if what you're suggesting is the recommendation is to terminate. We either have to accept or deny that recommendation. If we accept it, then in theory, the employee has been terminated, and then he or she has the right to appeal. But that's not the way that this sounded to me. It sounded to me as if the fact that this is what is going to be recommended.
The recommend is to assign it to the administrative judge.
Okay.
There is no recommendation to the school board to terminate an employee. That is crystal
Well,
clear.
that differs from what
The
what
charging
Mr.
letter was issued. In response to the charging letter, the employee requested a hearing. We're honoring the request
right.
for the hearing. And I am not recommending termination until that hearing has taken place. So there is no termination. The recommendation to the board does not say termination. That was a letter that was issued to the employee. He has requested a hearing. The only action that the board has taken tonight is to assign it to the hearing officer, which Mr. Gresta has explained.
It's a good thing this doesn't happen very often.
Oh, it's very good. This
confusing.
doesn't, we have great teachers, and that's why it doesn't happen that often. So essentially, you are going differently than the charging letter. And Mr. Board Chair, I would suggest and recommend that the agenda be modified to properly properly describe what's being done tonight. Because, listen, I sit there too. I understand as a fellow elected official, I understand what it says in that agenda, what you vote on is what matters. It doesn't matter what anybody says. Everything can be said all day long, but if it says in the letter he's terminated and it says on the agenda he's terminated and you vote yes, that's what happens. Yes, it may go to an appeal board afterwards, so the agenda needs to be modified to properly describe what is actually being done, because according to the charging letter, that's not the process you're going to. You're being told that they're going to a hearing before a decision's been made, but that's not what the process is. So it sounds like they're going away from the normal process of this. I recommend you pull the whole thing and not terminate this man and let him go back and do his job, which he's very good at. Have a great day.
So I understand the way that the agenda is written, and it is confusing. So the question, Ms. DeAgresta, first of all, we voted on the orders of the day. We voted to accept the consent agenda. The only way, either we can go back and revisit it and remove and take 4C out of the consent agenda, and as been discussed here for the last 15 or 20 minutes, proceed as you've explained, and not make a decision or table it based on Mr. Nunn's argument that the wording in the agenda, and in fact, the official record says termination. Now, it sounds to me, he's right. I mean, but I'm no expert, fortunately. I guess that's why I went to business school, not law school. So can you advise us as to whether or not we can go back after the fact, pull 4C out of the consent agenda and deal with it in the manner in which been described here? Can we do that after the fact?
If a board member wishes to make a motion to reopen the orders of the day, to make some sort of amendment to the agenda, that would certainly be in order. It would require a second, and then you could discuss whatever change you were looking to make. Whether you wished to revise the title of one of the agenda items, whether you wished to remove it from consent and place it somewhere else on the agenda, or do some other action, that is certainly within the authority of the board to reopen your adoption of the orders of the day portion of your agenda if you wish to do so. Yes, sir.
So can I have a motion to reopen the orders of the day?
So move in second.
All right. All in favor?
Mr. Barefoot?
Yes.
Mr. Barefoot?
Yes, ma'am.
Before we move forward, there was something else that I'd like to add to this. I reached out to Dr. Moore earlier on this same concern with regard to the letter and what was being proposed tonight. My concern as well, so that if there is someone who makes a motion, I'd like them to consider this as well within the motion, or maybe I'll do it, I'm not sure. If you look at the second paragraph of the letter, it says, I will recommend at the school board meeting on July 20th that your employment with the district be terminated effective July 21st. The school board meeting will be held at the offices, and then of course it says the address. The next paragraph just states what the teacher's rights are, and that he has an opportunity to request a hearing. And if he requests a hearing, it explains the process thereafter. But I think there's validity in the concern of how it was put on the agenda, and this charging letter has the wrong date. Essentially, what's being presented to us today should actually, and I understand it wasn't intentional. I understand that the letter, this is backdated July 1st. So this was sent to the employee on July 1st, and that the intentions were to bring it to the board on July 20th. It's my understanding that before July 20th, or on or before July 20th, there was a request for a hearing. So that kind of delayed things a little bit, and Dr. Moore can correct me if I'm wrong on the timeline. But I do think that there is validity in changing this charging letter or changing the wording of whatever is being presented tonight and how we're moving forward in it. Because I can see how there could be a question or concern, and legally, I want all of our tracks to be covered correctly.
The motion that was made and seconded was to reopen the orders of the day. So let's have a vote on reopening the orders of the day. All in favor?
Aye.
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 Opposed? All right, the motion carries. Now, I would like to propose, when it comes to the consent agenda, that we pull 4C from the consent agenda. Can I have a motion? I'm making that motion. Can I have a second?
Second.
All in favor?
Aye.
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 Aye. Anybody opposed?
Mr. Barefoot?
Yes.
Barefoot? Okay, can you hear me?
Yep.
Okay, I got kicked out right as you guys were making the motion. So could you please tell me the motion you voted on? Because you said it passed, and that's all I heard, and I didn't vote.
We vote, the first motion was to reopen to make an amendment to the order of the day. The second motion was on the consent agenda, that we pull item 4C for discussion. That was the second motion voted on. Now we need a motion to approve the amended orders of the day, which,
Okay,
So moved.
all right? So we've got an
Okay.
amended, I hope someone's keeping track of all these motions. Amended.
I'll second.
So, okay, we've got Dr. Schiff and Mrs. Barenborg. All in favor of the amended orders of the day? All in favor?
Aye.
aye.
Okay. That motion passes 5-0. Now, is there any, in the consent agenda, which I probably did it out of sequence, we've already approved item 4C for discussion. So, is there a motion to approve the consent agenda, having removed 4C?
Are you done with all public comment cards that you've received so far?
No.
We have to finish public comment before we get to the approval of the actual consent agenda and then move into the.
Can I?
But what I would like to see us get to is when we pull the item, that we change the title from termination to whatever,
Approval for hearing officer.
approval for a hearing.
Central hearing.
Because I think Mr. Nunn is correct. If this is a matter of public record, and we've approved something that is incorrect, that was not the intent, for whatever the reason was, as you said, Dr. Schiff, it's not exactly what was meant. It was out of sequence with the normal process, and I think Mrs. Rosario points out that once the person involved here received this letter July 1st, he requested prior to July 20th, when it was originally thought to be put on the agenda last week, that's when he requested this administrative hearing. So we need to change the wording for the record, I think. So we finish public consent, then we can go back and change, this is the one item that's been pulled, and we can do with it as we see fit, correct?
Yes, sir. Yes, sir.
Question.
You've moved it to action at this moment.
Okay.
Well, he moved it to discussion. Is that the same as moving it to action? And once he moves it
Oh,
to
I thought he said
action, he said.
I want to move it to wherever it has to be moved to change what we call it.
Which should be action. So-
Okay, then I make a motion, we can't make the motion yet. We've pulled it out of consent, so, right?
Yes.
All right, so let's get back to public comment. I'm getting a
Hold on. Do we
headache,
have
I
to
don't know
go back
about the
and make
rest of
sure
you.
it's properly in
I don't
action?
make to make light of this, but it's very confusing,
Hold it for discussion.
I think for all of us. And it's only fair to everybody that everybody understand as best we can exactly what the process is in the case of the,
Mr. Barefoot,
yes.
sorry. When you pulled it for discussion. We don't vote on discussion items. I think we have to go back, put it in action, which
That's
is
what I
where
just
we
said.
will amend it. But we didn't vote on that. We have to have a proper vote. Sorry, I have been this road before with people objecting to improperly run meetings.
I thought that's what we did vote for action.
Well, I think you meant action. What you said was discussion. For purposes of having the record be clear, we can't vote on it if it goes to discussion where we want it as action. So let's be clear and do what we have to do to do and undo and put it in action so that when it gets to action and we discuss it, we
Want
can
to make
change
a
the
motion
name
that
and
we
put it
take
back and vote
4C
on
and
it.
put it in action. You're making that
I
motion.
move that we move, I move that we take item 4C out of discussion and put it under the action agenda.
All right.
Second.
Second. All in favor?
Aye.
Aye.
Did we do that right, Mr. Gresta?
Okay. Yes,
Is
ma'am.
that right? Like can we take it out of discussion, move it back to action, we're good?
Yes.
And then when we get to the action, we can say we want to change the name, we vote on it, we're done. Ish.
Yes.
Okay.
Mrs. Maddox, you wanted to?
Mrs. Berenborg has a question.
Yes, ma'am. Sorry, I couldn't tell whether you were voting yes, Mrs. Berenborg, or not.
I was like, I have a question. Because this is a legal matter, and now you've moved it, because when you said you were going to move it to discussion, I thought that's when I had to put my hand up, because if we're talking about legal matters and there are some concerns about laws involved in this, how much can we discuss as a board? Because again, if it's quasi-judicial, then we have to be very careful.
The purpose of moving it out, 4C, is so that we can change the title of the item from 4C, which says termination, to some other choice of words which actually reflect what the next step will be, which is the administrative hearing.
Mrs.
Okay,
Berenborg,
so
we moved
we're
it
not
out
going
of,
to discuss the situation of the case at all. I want to make sure that we're very clear on that.
This is just changing the item that was listed on the agenda. The wrong choice of words were used. And we want to, ultimately, the goal is
Okay.
to change those words and not get into the specifics
Okay,
of the case.
Then with Robert's Rules of Order, move it through that went right now, before we, because we technically have it, you need to label after the name that you want it to be. Correct, Mrs.
Mrs. Berenborg, we cannot understand a word you're saying. It's all garbled,
Sorry about
unfortunately.
that. Okay, I'll type it.
Okay. Maybe it's cocktail hour.
I think it's her internet connection, not her, it's not imbibing.
Maybe it should be. All right. We're going to continue on with citizen input. Next speaker, Eddie Flores.
So I have this letter I wrote that apparently can't really talk about now, but I do have a question. Once this moves on to the next stage and whatever decision happens, this is for the lawyer, I just want a yes or no answer. Does the board have the power to overturn a recommendation for termination, yes or no? You could stop my time.
My understanding is if there's something that was not presented, correct me if I'm wrong, Mrs. Diagressa, if there's something that was not presented, fact-based, or something that there's a question about the interpretation of the evidence presented, then we don't necessarily have to abide by the recommendation. But basically, we have to stay within the confines of the recommendations and the reason why that come from the administrative law judge.
If they are on a point of law or policy.
Right.
We have to stay within law and policy.
So if you can't overturn it, then this would be our time to talk. Because
No,
it's impossible.
no, at the hearing is your,
At
I'm
the-
sorry, I shouldn't be.
If you have something to say in support of or against you go to the administrative hearing. That's when you want to be on the record.
Okay. And the answer was yes and maybe?
I would say that the answer is probably we would not overturn the the recommendation of the judge, unless it was determined that there's something new information was presented that should have been, it wasn't, or that something was misinterpreted. And I'm being generous here in terms of my response. But Mrs. Diagresta, you feel free to correct me.
Mr. Barefoot, may I?
Am I going to turn on?
Go ahead, Mrs. Diagresta, go ahead.
Mr. Barefoot, no new evidence can be presented to this school board once the recommended order comes back. So you would not be allowed to review any new evidence. But if the school board reviews the recommended order, it reviews the transcript of the hearing and all evidence and testimony and other information presented and accepted by the hearing officer. And the hearing officer says in the recommended order that the light was green. When every piece of testimony in the record says the light was red, the school board can decide to go with the testimony in the record that has been unrefuted. There are times when the school board can overturn a recommendation of a hearing officer. My best advice to you is the answer is it depends. I have no idea what that recommended order is going to say, so I'm not going to sit here and say, yes, you can overturn that recommended order. It depends upon what that recommended order says.
Okay.
Okay.
Mr. Barefoot,
Yes?
I have a
Mr.
question.
Go ahead.
Mrs. Diagresta, what I hear is that there will be a recommendation. What I heard earlier is that based on that recommendation, the school board will meet and the school board will then decide whether to accept the recommendations or not. Is that correct?
Mrs. Rosario, yes, that is the basic process, but the school board, under the law, under the Administrative Procedures Act, the school board does not have carte blanche to do whatever it wishes with a recommended order. The discussion or the explanation that we had a little earlier was under the Administrative Procedures Act, the findings of fact by the hearing officer cannot be changed by the school board unless there is an obvious mistake. That the testimony, for instance, the testimony in the transcript all said the light was red, but for some reason the administrative law judge made a recommended order that said the light was green. If all of the testimony in the record is the light was red, and there's nothing in the record that the light was green, then the school board may correct that error in the recommended order. But if there is testimony in the record that the light was red and the light was green, then we must rely upon the hearing officer to weigh the evidence, to weigh the credibility of those witnesses and decide that fact, whether the light was red or green. The same would apply in this case. I mean, I don't know what the evidence is going to be in the record, but if there is competing testimony, we must rely upon the hearing officer to make the decision of which piece of testimony is more credible. So you would not be able to change that piece of the recommended order.
No, I get that. And
Okay.
my question was not about whether we can change the recommended order or change what is being recommended to us. But on the opposite end of that, when it is brought to us, when the recommendation is received by this school board would then meet in the quasi-judicial fashion that you mentioned earlier,
Yes, ma'am.
process.
Yes, ma'am.
And we will discuss what was recommended, the recommended findings, and then at that point, this school board would then discuss and either accept the recommendations and make a final decision to terminate or to not terminate. Correct? Am I correct in that?
Yes, the school board would be in a
Okay.
position
So-
to enter a final order in the matter.
Okay.
And I mean, one of the options is to accept the recommended order as presented and just adopt that as your final order.
Okay.
Or
So
you-
it's not, so Mr. Barefoot, I would just caution to say that in all likelihood, I think your wording was that this board would more than likely accept the recommendation being brought down, because we don't know that yet. We haven't looked at the evidence. We haven't even began this process. So at that point, when the school board meets and discusses after the whole process is completed, that's when we would, as a board, come to a decision. So we do have ultimate authority even after the recommendation. Not that we have authority to change the recommendation to be brought to us, because that was clear by Mrs. Diagresta. But at the very tail end of this entire process, it's up to the school board to look at the evidence and the recommendation and then come to a final decision as to where we're going to go moving forward. At this point, I think that this is another something new for this school board. And I think that it would probably be prudent of us to have a further discussion, maybe not tonight, maybe somewhere in the middle, to have a further discussion on this process in detail.
We already
because
decided,
all of
Mrs.
us-
Rosario, not to interrupt you, that this is going on the workshop agenda for August 28th, when we will do just what you suggest.
Excellent, excellent. Well,
All right.
there we have it. All right,
Thank you.
thank you.
The next speaker is Dave Haller. Okay. Next speaker, Antonio Castillo.
Hello, my name is Antonio Castillo, graduate from Sebastian River High School. I just want to say, Mr. Ru's a really good teacher and from the automotive program, and he should not be terminated. Thank you.
Thank you. Remember, no character. And it's okay if I call your name and all your questions have been answered, or if there's a question that anybody still has about the process, which has really been the discussion, feel free. The next speaker is Rico Correa. Left? Okay. Next speaker is, I may mispronounce this, April Gerke? I'm sorry.
Good evening, my name is April Yerke. So no character witnesses, obviously. What will be the status of this employee until the hearing takes place?
He remains employed.
Thank you.
Next speaker is Ronald Gerke.
Good evening. Obviously, what I had planned to say and what I'm going to say are very different, and I've been thinking through this. I am Ron Yerke. I am a IRCEA executive board member, and what I would like to express is my disappointment that this could not have been handled without going this far. And obviously, I can't talk to the specifics, but it is my belief, as well as the rest of the board and our president, Jennifer Freeland, who is not able to be here tonight, that this did not need to go this far. Now, on a personal question, I would like to ask, is it not possible that the board could consider this without it having to go to a hearing at all, and a decision could be made about termination without the need for a hearing. Thank you.
The next speaker is Eric Bogovich. Bosco, we like Bosco.
I like that, right? Hi, I'm Eric Boscovich. I am the culinary teacher at Sebastian River High School. This is my 6th year teaching. I'm not going to read exactly everything I had, and I had it down to 2 minutes and 45 seconds. I am going to read, though, something that's actually in our contracts and everything about disciplinary defined. Discipline under, I can't read it, I think it's Article 5, something 1, discipline, number A. Discipline of a MBA may be progressive. Used to be shall, now it says may. So you can progress it if you choose so. So what's the choice of being progressed to a termination or to beyond this point? I don't know. I can't speak on his character and such. If you want to speak facts, facts is he has a 92% pass rate for his certifications, which says excellent for the school and district, and acceleration points for grades. Is that still character? That's factual.
But the facts are what should be presented to the administrative
Okay,
law judge.
well, I was going to say, that's just speaking on how the class does, the students do in this class. Not actually his character, I guess. I don't know. Maybe it does. But anyways, I just wanted to, thank you for your time, I guess. That's all.
Next speaker, Jeffrey Plate. I'm trying.
No, that's okay. Good evening, everyone. Thank you so much for letting me speak. And yes, Plate, it's just like it's spelled. I guess I won't say much. A lot of people have already said what I was going to say, and I don't want to take up the board's time. I kind of agree, though, with just Mr. Yerke. I was wondering if something could have been done maybe before it had to go to an administrative law judge. I didn't know if tonight, if the board could vote not to send it there and just keep Mr. Rue employed. And just move on from here. While I agree, mistakes are always made and there's things we could learn from. I didn't know if there was something the board could do tonight where it doesn't have to go to the judge and go to that point. If that's the way it has to be through procedures, I understand you guys know a lot more about this than probably I do. But that's really all I guess I will say then, and I hope everyone has a wonderful evening, and thank you so much for your time then.
Thank you. Next speaker, James Cole.
Actually, I need to ask if I'm allowed, am I allowed to speak to the effect that this will have on the program?
That would be part of the hearing.
I think that should be part of the hearing.
All right.
Next speaker, Sebastian Lowe.
Hi, there's not much for me to say, but what I will say is I graduated in the class of 2020, and I think I can speak for everyone that was in my class with Mr. Rue that we would like you to pull 4C from even going to an official hearing. Thank you.
Thank you. Next speaker, Michelle Gay.
My name's Michelle Gay. I run the O'Reilly Auto Parts in Sebastian. I'm here on 4C as well. I can't say much on his character, but I have to agree that I would like to, see if there is a way that we can just pull it completely and not have to go through any more steps than has already gone. That's kind of all I can say, I guess. Thank you.
Thank you, Ms. Gay. And I think we have one more. Last speaker is Nicholas Kagia.
Good evening. I'm the attorney representing Mr. Rue in this matter, so I'm speaking on his behalf. I'd like to thank the board for their time this evening. I want to thank all the speakers who have spoken. And Mr. Wu wants to thank them for their enthusiasm and for their restraint, really. I also want to thank Ms. DeGresta, because as one of the only people in this room who probably understood everything she said, she did a wonderful job at explaining it all. The only thing I would ask this board is to consider what one of the speakers said this evening, and that was that you can discipline Mr. Rue without terminating him. Okay, there is an option of disciplining him and not terminating him. There are other steps before termination. And so we would argue that Mr. Rue's actions, even if found to be contrary to law, do not rise to the level of termination. And we would ask that you consider that when making your decision. Thank you.
All right. Pardon me? Two were not called? Well, whoever, please come up and introduce yourself. I'm sorry, I read all the names of the cards I have, so.
I'm James Holler. It was on the card, but it's okay. Just like everybody else, my speech had to get ripped down a little bit, but I can say this. In a town where a lot of people can't go to college, the working force, like mechanics and stuff like that, is a dying breed. And to hire a new teacher, it takes a lot to build more like trust and back with the school. Keeping this teacher, he's been here for a long time. I know it's character, sorry. Sorry. But hiring a new teacher would be different and a culture shock for the school. So I'd like to say that. And I recommend pulling this whole thing because at the end of the day, it shouldn't be here at all. Thank you.
And I apologize, Mr. Holler, I guess it's your brother perhaps that his name I called, and there were two Hollers back to back. Please.
Thank you so much. Again, Michael Brown from Heritage High School in Palm Bay. And as I sat here, of course, I had a speech prepared as well. And I would like to ask you, and thank you again, Ms. DeGresta, that your grasp of the facts and the legal terms, very, very knowledgeable. Thank you very much for that. I caution you, though, that our human aspect is being torn down by being stuck in the mire of those things. Stronger together. How do we transform education and inspire our students without learning ourselves as educators? Thank you for your time.
All right, well, that ends the public comment. I would like to thank all of you. I guess you didn't know when you came here tonight that we were all going to get educated on this process. It's complicated, but maybe it isn't that complicated, but it can be confusing. And I know I speak for my fellow board members. I appreciate your interest in all of this. Having said that, the next item of business is the approval of the consent agenda.
There's no more items.
And so can I have a motion to approve the consent agenda
As amended.
as amended?
So moved.
Second.
All in favor?
Aye.
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 Anybody opposed? Motion carries at least 4-0, if not 5-0. We now go to,
Action.
I'm looking to action, correct?
Yes.
And do we want to take this action item up first, and then we'll do the rest of them? All right. I don't know what the proper words to use, and maybe somebody can help me here.
Make a stab at it?
Sure. Dr. Schiff, go ahead.
The, I just want to get to exactly where the wording is here so that I don't. There it is. I move to change the wording of item 4C from approval to terminate instructional staff employee to approval to allow the superintendent to move towards an administrative hearing for the employee. I don't know if I got that right.
Mrs. DeAgressa, can you
Be here.
recommend where what we're really recommending is that the process be moved to an administrative hearing?
If I may
Please,
suggest,
'cause
I
I
mean,
didn't get it.
I think the way Dr. Schiff started is certainly appropriate to,
Lost it.
the subject line of the action says approval to terminate instructional staff employee. So to remove that subject line and replace it with approval to refer to the Division of Administrative Hearings for the assignment of an administrative law judge to handle this matter.
Do we have to say what the matter is?
No.
I mean, to handle the recommended employee termination.
Okay.
So do you want to recommend?
So I recommend that we change the wording of item 4C from approval to terminate instructional staff employee to approval to move,
To refer
to refer,
to the Division of Administrative
To the
Hearings for assignment of an administrative law judge to handle the recommended employee termination hearing.
can we just, like what she said?
Yes, yes.
Okay.
And Dr. Jones, you seconded?
I'm fine with that.
Any further discussion?
Yes, I do have a question.
Yes, ma'am.
The issue came up about not sending this to an administrative judge. I want to clarify legally. To be clear here, because this was a request by the employee, we cannot make a decision to not do what the employee requested. Am I right?
Correct. Once the employee has requested a hearing, we've got to move forward with.
We have to move forward.
We have to move forward with the
can't not have a hearing
hearing.
that the employee has requested.
The only way under the law is for the employee to withdraw their request for a hearing, which I am, I don't represent them, I'm not suggesting that they do so. But then, if there's no request for a hearing, the recommendation to the board is for a termination, and so we kind of get into, in my opinion, an area that impacts the employee's due process rights, and so I don't want to put the employee in that position. So they've requested a hearing, so you should move forward with that hearing. If some other steps need to be taken as part of that process, then the superintendent side of the table and the employee side of the table can have that discussion. But at the moment, the request from the employee is for a hearing, and so you should move forward on that path.
That's what I wanted to clarify. Thank you.
I have a question.
Yes, go ahead.
Mrs. DeAgresta, to the point of the date on this letter, I understand what the amendment is, what the recommendation, what the change is being requested of us in terms of the charging letter or moving forward and changing the wording on this. What about the date that is in this charging letter here? Would it be appropriate for us to ask the superintendent to write an amended letter, an updated letter, as a result of today's school board meeting? Because that second paragraph there still has me on, I will recommend to the school board on July 20th, effective July 21st, that the employee would be terminated. So how do we then move forward after today with this particular charging letter?
Mrs. Rosario, this letter was issued by the superintendent as a charging letter against the employee. Assuming the pending motion passes, this matter is then referred to DOA to be handled. At that time, if the lawyer who is representing the superintendent believes that this letter needs to be amended, that is something that would be handled during that administrative hearing process.
Okay. So we don't need to worry about the date then?
Correct.
And the
Yes, ma'am.
information that's in that charging letter?
At this point, the issue or the question before the board is whether or not to refer this to DOA to be handled. And if the board votes affirmatively with this revised title, if you will, and the item as recommended, then the Division of Administrative Hearings would handle the rest of it.
Okay. All right. Thank you.
Of course.
Any other comments from board members? There's a member of the audience would like to speak to this action item before we vote, and that person has already spoken during citizen input, not, so.
And Mr.
Guidance, please.
Mr. Barefoot, on the procedural aspect, your board policy says that anyone, of course, can speak, whether it's during citizen input or to a specific action item, but they only speak once to the item. So if the individual has already spoken to the item, then they would, under your board policies, they would not be allowed to speak a second time just because it's been moved from consent to action.
All right.
But you're the presiding officer.
I have a comment before you go.
Go ahead, Dr. Jones.
So citizen input, we're all finished now, and
Unless you all, we should keep moving, or,
Well, we're on action now,
you
so
need-
it's a
you need
different, it's
to-
not citizen input. We're done with
Right.
citizen input. This
I
is
wanted to
action.
make sure that he wasn't able to speak again. I think when we listened to everyone here, as has been said, board members cannot speak to one another. And obviously, we've all been following this very closely because of the questions we have had, with the concern with the date, the time, the wording on the agenda. And I just ask that we follow the procedure. And as Ms. DeGressa said, I believe that the teacher has requested a hearing. So at that public hearing, whenever it is, just make sure you speak so that you are heard. And again, as far as the board making a decision, we don't have all the facts. We don't have everything that went on. We were not part of this investigation. So work the process through the hearing, and then that will come back to us. And as Ms. Rosario said, then we take a look at that and look at all the legal aspects, and then we go from there. So, and I certainly understand. I know you were not able to talk about character, but I certainly understand, and I hear you as far as the value of teachers and the value of this teacher and to our program. So I'm just saying, follow the process. Thank you.
all right. I know that, Mr. Nunn, you'd like to speak again, but as soon as we start making exception, it becomes the rule.
Technically, Mr. Barefoot, I spoke to public input. Just because the item was technically under public input, it is now an action agenda item, which is actually a separate item at this point.
And when I read the rules of the road, if you will, at the beginning, you speak to one or the other, but you can't speak twice. Unless someone has a problem, this has been, I guess I'll run the risk of being in violation of our own policy if there's no objection from my fellow board members, and let Mr. Nunn speak, even though it is not in our policy to do so.
My only concern,
I don't have an objection, Mr. Barefoot. My only concern is that it's the same item. Even though it's on a different, it moved from consent to now action, it's still the same item that we're discussing. So that's my only concern.
I
So I'm gonna say
understand.
one thing about this. Because it's clear we haven't been through this process before, because this is clearly new to all of us, and we have had to have the item, this issue explained to us in ways that we didn't anticipate, I think we make a one-time exception, we clarify it's a one-time exception, and that's it, end of story. Because my concern, as you said, is if we allow it one time, we then allow it every time. And my concern, and this has nothing to do with you, Mr. Nunn.
Understood.
Because I actually am interested in what you have to say. But I don't want to open a Pandora's box where every time we have a meeting like this, as you've seen, sometimes we go 9 hours of public comment.
Yes, ma'am.
So I want to be cautious and conscientious about setting precedent.
Yes, ma'am.
So that's just my concern, Mr. Barefoot.
Mr. Nunn. Do you want to speak, Mrs. DeAgresta?
I do apologize. So I will be quick. Of course, once again, my name is Christopher Nunn from Sebastian, Florida. Two things. First, with the agenda item, I would suggest also striking the charging letter from the agenda, since that procedure is not factual in nature. I would restrict that from the agenda as well, taking it out so that nobody is confused at the clarity of how this process works. And I'm sure the attorney could add the proper process to this so there is no confusion for today, tomorrow, and down the road. Secondly, the employee only asked for a meeting because a hearing because he was recommended for termination from that charging letter. That is factual. Factually, he requested it because he was told he was being terminated if you, 5 elected officials, voted to terminate him. That is what the charging letter said. That was what the basis of him requesting a hearing was based on. If there's not a letter requesting his termination, there's no hearing required. You could handle this in-house and do what you need to do to work on making things a better place, to take a teacher that's an amazing teacher and keep him in-house when teachers are so hard to get, and do what you can to discipline him in-house without sending this to a hearing. He's only going to a hearing because the assistant superintendent signed a letter that said he should be terminated. That's facts. Not Mr. Moore, but the assistant, because that's who signed the letter. So I would suggest that you remove the letter because the letter does not represent the facts as it's being put out here tonight. And secondly, just do the right thing. You can make the motion to pull this item and choose to have Mr. Moore handle this in-house and keep a great teacher. Thank you.
Well,
I don't think we can do that. There's an internal process that the district went through. The response from the individual being potentially terminated was to request a hearing, and that's basically what we're about to approve, because we have not voted on this revised wording.
My suggestion, Mr. Barefoot, my experience on this board is that when we make decisions on the fly without carefully considering them and knowing all the facts and implications of those decisions, we wind up with unintended consequences because we made a decision that wasn't fully considered without all the information on the fly. And I would, irrespective of whatever are my personal feelings, one way or another, I don't recommend that we as a board do that. Anytime we've done that, we get into trouble.
Do what?
Make a decision on the fly about charging letters and recommendations and what district administration has or hasn't
Right.
done. As Dr. Jones said, we don't have all of the information at our fingertips, and so.
I think at this point in time, we've got a motion on the floor with new language that recommends that this go to a administrative law hearing. So I'm going to call the question, unless somebody's got a further comment. All in favor of that motion? Signify by saying aye.
Aye.
Any opposed? All right, the motion carries 5-0. All right. We now move to the regular scheduled action items. And the first one, Dr. Moore?
This is action item,
Just
I'll
wait
wait
until the
a
room
little bit
clears.
so we allow the individuals to clear out. Thank you for staying. The second item on the, action item 5A is the updated approval of our district strategic plan and African American Achievement Plan as discussed at workshop. This is a very innovative plan in which we have had the time to work with staff to review and update our strategic plan. Very aggressive plan. As discussed, it increased the clarity and communication of our district priorities, improve the alignment of our human capital resources, increase the integrity of focus on areas in need of improvement, and improve the implementation of fidelity, while at the same time reducing redundancies in strategies and implementation and outcomes and monitoring. So we were able to take the significantly long African American Achievement Plan and align it and have a crosswalk supporting document, very narrow and deep focus within each of our 5 areas to create a strategic plan that will continue to set the bar across the state in terms of how we push and guide the work here in the School District of Indian River County. And that is the item.
All right. I will call for a motion to approve.
Move approval of the strategic plan and African American Achievement Plan as presented.
A second?
Second.
Dr. Jones? Any further discussion? Dr. Jones?
Just a very big thank you to Dr. Jacobs and Dr. Moore. I think any of us who have looked at strategic plans and our African American plan, just blending them together like we have, I think it really aligns itself with our areas of concern with our students and our whole strategic plan and our guiding principles. I am very excited about the fact that the African American Achievement Plan is embedded so well in this instruction and the expectations that we have. You know, we have some very big expectations, and we're all awaiting some of the other scores, hopefully this week. And I know that through the Equity Committee and our, striving for unitary status, this will be a plus for our students. And I love the fact that the curriculum maps are very specific in what we're doing in K-12, as are our standards and state statutes. So I think this was a long time coming for blending it, and just a very special thank you.
Yeah, I'll just say a quick.
Sure, go ahead, Dr. Schiff.
Thank you. We discussed this last week at our superintendent's workshop in detail, so I think most of our comments and dialogue came out at that. And if anybody's interested in seeing any of that conversation and hearing board members' questions, please refer back to the superintendent's workshop of last week. But at that time, many of us complimented the comprehensiveness of this document, the ways it ties things together, the use of language and targets and strategies and action plans and theories of action that I haven't seen since I've been on the board, and I haven't seen since I've been following the board for a number of years before that. Dr. Jones is better equipped to talk to the history than I am. But thank you for all of that work and presenting a document that has clear targets and strategies and theories for how we get to where we believe this district can go. So that's it, Matt.
Yeah, I think like a lot of strategic plans you'll see from the business sector, not only has goals, but it actually action steps on how you're going to get there, and timeframes. And Mr. Fagan will have his moment in the sun in a minute, but also the dollars and cents associated with the strategic plan, which is no small feat to tie everything together so that you actually can afford what it is you're planning to do strategically. That was a mouthful. Can I have a motion? I already got a motion. All in favor?
Aye.
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 Opposed? Motion carries 5-0.
The next action item is the approval of the FSBA advocacy position. This was discussed at our last convening at the request of Dr. Jones and the consensus of the board. I added this item for the board's consideration. With that, I'll turn it back over to the chair.
We did discuss this. I will just read quickly. The responsibilities of this position are based on the following criteria. Participation on this committee with statewide representative, 1 rep from each school district. There are 67 districts. Interaction with policymakers and stakeholders to promote public education. The opportunity to be considered to serve on the legislative or federal subcommittees. There are monthly meetings and additional meetings perhaps for subcommittees. This is for advocacy and communication leadership, and then bringing the work of the committee and subcommittees back to our school board so that we're up to date. Dr. Jones.
Thank you. I brought this up at the last meeting for discussion. Thank you. We received an email around July 8th from Ms. Esplin, and I told her I was interested. And then right before our workshop, I added it for discussion because I knew that had to be, elected by the board. I did double check because I wasn't sure last time if there was required travel, and I talked to Billy Ann Gay. There is no required travel. If you get on a legislative subcommittee, they do have some meetings like Central Florida, but that would be up to you if you wanted to come. So that's if you're on the subcommittee. I just thought that we should have representation. I think the FSBA is a wonderful organization as far as training and professional development and the conferences, new school board member training, and just keeps us up to date. So I would certainly be honored to serve, and I just think we need representation because when I talk to Billy Ann Gay at FSBA, they're not always exactly sure what they're going to talk about as far as advocacy, and they kind of get together on that. So whatever the topic may be this year, I'm not sure, but I'd certainly be honored to serve with that.
So I don't know if this is how we haven't had this position before. We've had a legislative representative generally, but we haven't had an FSBA, a person on an advocacy representative to FSBA. And I'm not sure how this works. If we are approving the position, but if in that, I nominate Dr. Jones to serve in the advocacy position, and I don't know if this is like something you nominate or something, like what you do. But I guess I recommend that Dr. Jones be approved to serve in the FSBA advocacy position for our school district.
I will second that. Any further discussion? Mrs. Berenborg, Mrs. Rosario?
Yes. Yes, I have a question. Maybe this is for Dr. Moore. Dr. Moore, I'm not sure who would answer it. What is the role of Eugenia? I always forget the name. Eugenia?
I'm drawing a blank on Eugenia.
We don't.
Looks like Dr. Jacobs knows what.
What is the name? Gosh, I don't have it in front of me.
Encenia Rutledge, I think
The one
is
that
what
we
she's referring
received
to.
legislative updates
Oh,
from.
Jessica.
No, Encenia.
Encenia Rutledge.
Rutledge Encenia.
I am sorry.
Yes, Rutledge Eugenia. Thank you so much. I always
All right,
forget that
thank you,
name.
and I apologize.
Rutledge Eugenia. Can you confirm for us what the role of our relationship or our membership with Rutledge Eugenia is?
I know who you're talking about. Yes, I can. I think it's significantly different from the item that stands in front of us now. That organization provides information to cabinet and board members regarding the legislative process, what's moving through, so we as a system can be informed and create either a position or be prepared for shifts or changes in policy. So it is an opportunity for us to continue to be informed as the shifts and possible shifts and changes in law as we move through the process in Tallahassee.
Thank you. Does Rutledge Eugenia, sorry, I always mess that up. Do they lobby for us?
They do not lobby for us, although they might be able to make connections or opportunities for us to advocate our stance while in Tallahassee. but not officially lobbying, no.
Any further
So
comments or questions?
when we create our legislative priorities, what happens from the moment that we, and I know the process here, but for those who are listening and don't understand what we're talking about and why this is an important conversation, what happens from the moment that this district creates our legislative priorities, which are specific to the needs of Indian River County School District? It may not be the same as even our neighboring districts, Port St. Lucie, any other neighboring districts. Their legislative priorities might be completely different. So from that moment, what happens?
Through the chair, once we identify our priorities, and you are correct, these would be the board's priorities. That's opportunities for us to advocate for changes or non-changes, no modifications to proposed law in order to benefit the school district of Indian River County. There would be opportunities for us to partner with other districts who had like concerns, in which we could be, stronger together, because it would be a higher number of individuals advocating for that particular change or modification. So from a board's perspective, we're looking for advocating for what is best for us as an individual district. From the 67 districts, Florida School Board Association, this is the opportunity for us as a district to have influence over what I understand would be their priorities. So I would highly recommend having one of the board members at the table and helping define and craft what the Florida School Board Association's priorities would be, so we can stand behind those and have voice in what they would be. And when there would be situations in which we would not agree, we also have voice at that table as well.
So I thank you for that. What I'm concerned with is not that we don't have representation. I think FSBA is a wonderful organization. Their services have been impeccable for us. In particular, we became, just so that the public knows, we became members of FSBA right at the point when we decided we needed their help to search for a new superintendent, and as a result, we have Dr. Moore now as our superintendent. So they were instrumental in that process for us. So what they do really is incredible. However, their legislative priorities for FSBA might be very, very different from our local needs. And so where I think that we have, it's important for us to be at the table, sit at the table, so that we can share the perspective from this small school district to the larger statewide organization. On the flip end, my worry is that the influence of the larger districts might get confused with our own. And I don't want that. I don't want us to get mixed up, in the shuffle, and I don't want our priorities to become FSBA priorities. I need for us to understand that our specific needs are just as differentiated for us as they would be for everybody else individually. So that's my only concern.
Okay, Mrs. Berenborg?
Can you hear?
Try again.
We did hear the sigh.
We heard that you're there.
If she'd like to type, maybe Kristen can read it.
Mrs. Berenborg, maybe if you type it into the chat, Kristen, Mrs. Maddox can read your comment for you, because we can't hear you. In the meantime, do we want to continue discussion?
Wait a minute, I think
If
we
you
have
have,
something.
well, we're,
I can't type it.
I have her comment.
okay.
She said, I spoke to Billy Ann Gay, and there is one mandatory in-person meeting on September 13th in Kissimmee. Also, I want to be alternate.
Okay. I spoke with Billy Ann too, Terry. She said it is not mandatory to travel to Kissimmee. That one is not mandatory. They want you to if you can, but it's not mandatory. And if I could just respond to what Ms. Rosario said, FSBA and really does want to have a representative and an alternate from each area. Looking at our legislative issues, our primary legislative goals as the Indian River County School District, those are the goals of Indian River County School District, and that would never be changed. And I would be there as listening, participating, and making sure I bring it back to the school board. They are 100% advocating for public education. What they will advocate each time, I'm not sure. That'll be a discussion. But I think we need representation. I can certainly see if it's not aligning with our goals or our strategies, and I would talk with Dr. Moore about that and bring it back to the school board. So I would just be a representative, bring it back to the school board, letting you know what the information is being shared, and I think it would just be a plus to have. And I'd never, ever go against what we are doing as a district. And I think FSBA has some overall goals, and know Andrea Messina quite well. I just think they want to do their best every single day to advocate for public education, and I would like to be our representative.
Can I follow up on that? You know, you can't have a voice if you don't have a seat at the table. And my concern is that, not my concern, for me, this would be a priority because we can't actually bring Indian River County's concerns or priorities to FSBA or to the legislature if we're not at the table. So this is not a one-way, as I see it, this is not a one-way communication about pushing FSBA's agenda, but is rather making sure that Indian River County's agenda is included and is voiced and has representation in the decision-making of FSBA as well.
I agree with that.
Mrs.
Go ahead.
I have another comment from Mrs. Berenborg. She said, Dr. Jones, what Dr. Jones states is perfect. The liaison does just that. She brings info and relays it.
Thank you.
Okay. So,
So should I make a motion?
and
There is a motion.
Mrs. Berenborg would like to be alternate.
So,
Can we,
yeah, so I'm making a motion to approve Dr. Jones as the FSBA advocacy representative with Mrs. Berenborg as the alternate.
I will second that. All in favor?
Aye.
Aye. Opposed? Motion carries 5-0. Thank you both, Dr. Jones, Mrs. Berenborg. I'm sure you will represent us well, and you will also provide feedback as needed.
Yes, sir.
All right.
Where are we?
Now we go to the new agenda item. We get to the, not that the rest, all of this wasn't important, because it was very important. However, we're now going to move to budget and millage rates, and I will turn it over to Dr. Moore.
Excuse me, I'm sorry.
There's-
There's discussion here, is
Yeah,
that?
my recommendation through the chair is to move discussion following the public hearings related to budget, because there is a COVID update I'd like to provide to the board and seek some guidance there. So my recommendation is to move to the public hearing, in which I would turn it over to Mr. Fagan, because there's a big audience out there for that.
To the chair, thank you, Superintendent, to the board. Thank you for this opportunity tonight to talk to you about the 2021-22 budget highlights. This hearing is the first of two public hearings required under the Florida statute to provide the public with an opportunity to give an input to the proposed tentative millage rates and proposed tentative budget for 21-22. There was one workshop held to discuss the tentative millage rates and the tentative budget. It was held on July 20th, 2021. This public hearing was advertised in the Indian River Press Journal, also known as the TC Palm, on Friday, July 23rd, 2021. These items were approved by the board on July 20, 2021. The second meeting that will be held is on the final millage, and the final budget will be held on September 9th, 2021 at 5:01, the J.A. Thompson Administrative Building. The notice to that public hearing will be through the direct mailing from the property appraiser's office via the trim notice. The proposed millage rate for 2021-22 school year is 6.2680 mils, or a decrease of 0.128 mils, or 2%, from the 2021 millage rate of 6.3960 mils. The total millage rate to be levied exceeds the rollback rate by 1.43%. This means on average, the average taxpayer in Indian River County will pay 1.43% more in school taxes in 2021-22, all dependent upon the property that they own. The decrease in the tax rate is because of the decrease in required local effort as required by the state of Florida and a significant increase in property values compared to the prior year. The district is levying the required allowable millage for the district to participate and receive FEFP funding from the state of Florida. FEFP stands for Florida Educational Finance Program. If the district does not levy these amounts as required by DOE, the district is subject to the loss of $48 million in state funding. There are two resolutions tonight to be approved. Resolution 2021-01, which is your tentative millage rates, and Resolution 2022-02, which is your tentative budget. These approvals are required for the district to be in compliance with Florida Department of Revenue trim requirements. TRIM stands for Truth in Millage. A quick breakdown of the millage rates. There are 4 millage rates. One of them is your required local effort. That's at 3.520. Discretionary operating is at 0.7480. Discretionary operating millage is 0.50. And capital projects is 1.50. Total millage rates, as we said, was 6.2680, or a decrease of 2% compared to the prior year. Based on these millage rates, the amounts to be levied are as follows. Required local effort, at your 3.52 millage rates. Amount to be raised, $74,111,244. Basic discretionary operating, 0.7480 mils. Amount to be raised, $15,748,640. Capital outlay, 1.50 mils. Amount to be raised, $31,581,496. Additional voter discretionary, 0.50 mils. Amount to be raised, $10,527,166. Total amount, total levy, 6.2680. Total amount to be raised, $131,968,546. As mentioned, the total levy exceeds the rollback rate by 1.43%. The notice of the ads that were posted, the trim ads, there was a notice of a proposed tax increase. For 2021, the district published a budget hearing. The reason there was a notice of a public tax increase is because the amount of revenue generated for 21-22 exceeds the amount that was generated in the prior year. Property values, which we mentioned is what caused the increase. Property values increased approximately $1.1 billion, or 5.3% compared to the prior year. The second part of this hearing deals with the adoption of the tentative budget for 21-22 school year. The board is requested to adopt the tentative budget and to certify the adoption by the resolution. The tentative budget amounts are as follows. General operating budget, $181,834,270. Debt service budget, amount $27,200,011. Capital outlay budget, $54,636,388. Special revenue budget, $25,563,750. Internal service budget, $32,606,751. Enterprise fund, $2,133,301, for a total tentative budget of $323,974,471. Thank you, Sue.
And
All right.
oh, go ahead, he's going to read.
Dr. Moore, have you documented that this public hearing was properly advertised in accordance with state statutes?
Yes.
We now recess this meeting to conduct the public hearing as advertised. The public hearing is now in session. Dr. Moore, are there any written responses to the advertised public hearing to be read at this time?
Not at this time.
The public is invited to address this issue at this time. Is there an individual representing an organization or his own personal or his or her own personal or public interest who wishes to speak? The chair concludes that the announced public hearing of July 27, 2021 has been conducted pursuant to notice and that ample opportunity to address this issue has been provided to all. The board meeting is reconvened at this time. So I will call a motion to approve resolution number 2022-01, which is the tentative millage rates. May I have a
Second.
first?
Oh, a move to approve.
Okay.
Second.
All right.
Thought you were making the motion.
Any further discussion? I recognize Mrs. Poisel for a roll call.
Mrs. Rosario?
Yes.
Your vote?
Yea or nay?
Yea or nay?
Yay. Can you hear me?
Yes.
Dr. Schiff?
Yay.
Dr. Jones? Yay. Mrs. Berenborg?
Yay.
Chairman Barefoot?
Yay.
Mr. Barefoot, the motion passed with a 5-0 vote.
Thank you. We now, any further discussion on the proposed budget? All right, Dr. Moore, have you documented that this public hearing was properly advertised in accordance with state statute?
I have.
We now recess this meeting to conduct the public hearing as advertised. The public hearing is now in session. Dr. Moore, are there any written responses to the advertised public hearing on the proposed 2021-22 budget to be read at this time?
Not at this time.
Public's invited to address this issue at this time. Is there an individual representing an organization or his own personal or public interest who wishes to speak? The chair concludes that the announced public hearing of July 27, 2021 has been conducted pursuant to notice and that ample opportunity to address this issue has been provided to all. The board meeting is reconvened at this time. I will then call for a motion to approve Resolution 2022-02 for the adoption of the tentative budget as advertised and presented at this hearing and to establish a final public hearing date on September 9th, 2021 at 5:01 p.m. May I have a motion to approve the budget?
So move.
Second.
Dr. Jones, second. Dr. Schiff. Mrs. Poisel, roll call, please.
Mrs. Rosario? Mrs. Rosario, yea or nay?
Yay.
Dr. Schiff?
Yay.
Dr. Jones? Yay. Mrs. Berenborg?
Yay.
Chairman Barefoot?
Yay.
Mr. Barefoot, the motion passes with a 5-0 vote.
Thank you. So the next item, and the next step to adopt the budget, and I recognize Dr. Moore.
That would be the,
Next steps in adoption of budget and millage.
Mr. Fagan.
Yes, based on your actions tonight, the board has approved the 21-22 tentative millage rates and the tentative budget, and the school district of Grand County will accept the 21 certification of school taxable values, Forms DR 420S from the Indian River Property Appraiser's Office, and authorize the superintendent to execute that document. The school district also will schedule a public hearing for the 21-22 final millage and budget on September 9th, 2021, at a special board meeting at 5:01 in the J.A. Thompson Building.
That is the item.
All right, well, before officially closing the meeting, I would like to thank on behalf of all of us, and it's already been mentioned, but the job that was done, not only in the strategic plan, but obviously the millage and the budget. Having been involved, at least in municipal government budget process, this was as smooth and as well done as I could imagine. And as I mentioned earlier, the alignment of the budget to the pillars of the strategic plan. Thanks to Dr. Schiff, I figured out after the fact that it was all color coordinated. And here I couldn't even claim to be, colorblind. But somebody else said they didn't pick it up either, but I won't tell you who that was. But at any rate, it was a job well done. And Dr. Jones?
Just a few words, and then I know we're going to end with discussion with Dr. Moore, but thank you, Mr. Fagan. We've said it many times. Want you to know I was at a value adjustment board meeting the other day, and I knew what they were talking about with trim and where we were going, and just having that discussion with the property appraiser. But it's really good to see as a board member and a community member and someone whose students went through the public school system here that we have a sound budget. Thank you.
So discussion, let me first start by apologizing to the board, Mr. Rue and his family. That debacle of an item is not reflective of how I do business, and it will be corrected and modified. So that is absolutely unacceptable. So we will take corrective actions in order to ensure we're precise and clear and very to the point with items as they come before the board. I think we lost Ms. Berenborg. Second, I want to quickly update the board regarding our COVID protocol. As you know, we are in the midst of a uptick here locally within our county and across the state of Florida. And there's been a great deal of conversation over the last several days, both across the state as, with other superintendents. We had a conference call yesterday with the Department of Education. All 67 superintendents had the opportunity to log on and receive that guidance earlier today, just prior to the start of this meeting. The CDC did provide recommendations. I have not had the time to review them, but they just did provide recommendations. We feel locally, based on what we did, and just a quick review of what we did, we moved to a mask optional environment towards the end of the school year and implemented that very successfully as we went into the summer programming and as I said, found a great deal of success. Now with this uptick, and it's around 15% positivity rate over the last 7 days. And that is very, very close to the peak in which of positivity rates going back to, let's say, was it January? So for us to do nothing would be the inappropriate action to take. But we will continue to monitor. I do need time to review the information that was released by the CDC today, circle back with the Florida Department of Education and other superintendents prior to making any recommendations or modifications based on that. But we do want to begin the school year with a heightened level of precaution, which means that we would heighten our level of implementation around our safety protocols, which means we would return to all of the safety cautions that we had in place, which would include the one-way hallways, the social distancing, maximizing social distancing in classrooms and throughout our school. The hand sanitizer as you enter the building available in classrooms, the maintaining of the cleaning schedules, the nightly misting, all of those things would continue to be in place. And I think one of the things that we need to understand is over the course of the next several months and possible years out, we're going to have this ebb and flow of percents going up and percents going down, and we need to be nimble enough to respond to those spikes as a district and honoring our community and honoring what we're doing to keep individuals safe, my recommendation is we would start the school year with highly recommending that masks would be required when social distancing is not possible. Still becomes an option, but it allows the school district to say that it's being highly recommended when social distancing isn't possible. And if there were any modifications above and beyond that, that would require me to reconvene the board and seek further guidance if that need be the case. But based on where I am now, my recommendation would be, to continue the path forward, allowing us the flexibility to increase our level of intensity, for lack of a better way of saying it, implementing all of our safety precautions that we implemented with a high level of fidelity last school year, with the only variance really being having the masks highly recommended when social distancing isn't possible. It allows us to respond. Now, when the percents go back low, we can go back to mask optional, but it does allow us that level of flexibility, while at the same time allowing us to keep the main thing, which is teaching and learning. We were very much looking forward to a traditional return to school. And I think what we across the nation need to understand, that tradition has changed, and what is normal is no longer normal. But we need to, as a community, be very responsive to what that reality is and be nimble enough to change and modify our practices. One size really honestly fits none when it comes to this reality. We say that for teaching and learning all the time. But that is where we are at. My next steps would be to circle back with these CDC recommendations, Health Department. If there's any modifications or changes regarding that, I would pull the board and reconvene the board at that time. But with that, I'd be happy to answer any questions you may have.
Questions, Dr. Schiff?
Couple things. One, when you say we're going back to social distancing, is that at the 3 foot or the 6 foot?
We're going to maximize social distancing, so we will look to do 6 feet when possible. But a typical classroom, secondary, would probably, and as I said, 3 feet with class size in our core classroom. We'll be able to attain the 3 feet and then maximize it beyond that when possible.
So are you saying that it is mask recommended when 3 foot is not possible?
When the social distancing, they don't call it social, they call it something different. Yes, when it is beyond that, yes.
And when you say we are switching, you said we are switching from mask optional to mask recommended. Is that's not quite a switch? Or what am I missing?
I think the switch would be, it would be highly recommended that you do wear a mask when social distancing would not be possible, opposed to optional. So it is a high level of awareness saying the recommendation is that you do wear it when social distancing isn't possible.
We've had a rough year with this, which we know. So mask recommended is only as good as the recommendation. There's no structure in place for teachers or students other than their own personal preference, correct?
Correct.
So because we don't have another meeting before we open schools again, I assume we'll revisit this carefully on August 24th and we'll, or 28th or whatever day it is, with the recommendations of the health department. And if the numbers now represent what was last year's peak, which is where we're starting school, which was not even, as I understand it, where we started school last August, correct? We started school last August, and I think between 5% and 10%, but I could be wrong. Don't quote me on that.
You're close.
So we're starting at 15% in the county, correct?
Through the chair, yes, that is correct. That is the percent positive over the last 7 days per 1,000 cases, so yes.
So what I'd like us to discuss, if not now, certainly when we come back, I'm concerned that it's a month between meetings, so it may be that we have to have a meeting between then, we don't know.
And if that needs to be the case.
But that there be some kind of guidance on at what point do we determine if rates are higher now than they, or match the peak of last year when we mandated masks. If we are higher now than when we started schools last year, how are we making the decisions if we have to change our current policy, which I hope we don't. I hope rates go down. I hope this is a blip. I hope a lot of things. But I think we're also gonna have to discuss at what point do we have to reconsider our opening plan.
Through the chair, and I wouldn't disagree with any of that, and that would be the very next steps for me to look at and say, A, do we need to reconvene the board? The reality of, where we were when we began school last year and where we're beginning school this year is significantly different. The executive orders that allowed us to make modifications to instructional models have not been renewed, they expired. The executive orders that allow us to, allow individuals to stay home, those things have all expired. Here in the state of Florida, there's been a hard, continuous push to allow students the opportunity to attend our public schools with the option of wearing a mask or not wearing a mask. At the same time, we have to look at those recommendations and determine what is in the best interest of Indian River County, and how do we, as a school system, create a space where children feel safe, they feel secure, and they're allowed to sit engaged in a classroom, and we have the opportunity to maximize their learning. So it is an extremely complex, disappointing situation that we're here, but we have to respond to that particular reality. I am confident with this recommendation. It does allow us to open schools. It does allow us to be nimble enough to make a modification or change if need be. And looking at response from parents and community, I feel comfortable with what we're doing now. But we still need to look back and modify if need be, if things continue to increase.
Okay.
Dr. Jones.
Oh, yes.
May I?
Oh, go ahead.
Oh, go ahead, sure.
That's okay. Did you call Dr. Jones
Oh,
first?
that's okay, go ahead, Ms.
No,
Rosario.
you go ahead.
Okay. Are we currently in the superintendent's report or closing remarks?
Discussion.
This is discussion?
Through the chair, yes.
Yes.
Okay, so I have a couple of concerns. As a superintendent's discussion item, you're asking us to make a decision on something that this board member was not prepared to discuss. There was no prior, FYI, I'm going to bring this up, there was no prior conversation between myself and the superintendent on this issue. I am unprepared with the rates of COVID going on or happening in Indian River County. So placing this on the item for discussion and then asking the board members to come to a decision at this point is not right. It's just not right.
Through the chair, I don't know that I'm.
There should be preparation. At least this board member should have been prepared to have this conversation. If you were asking us, Dr. Moore, to come to a decision or to have a vote on something,
No,
especially with our Safe
Mrs.
Schools
Rosario,
plan,
if I can
it
interrupt.
should come to us as an action item.
He's not asking this.
That's my first item. Yes, he is. He's
No,
just
he's-
asking
no.
us
No, he's
to
not.
give him
He's-
permission to be flexible and nimble so that if the spikes go up, he's now asking us to allow him the flexibility of going back to the same plan that we had before.
No, he's not.
So
He-
at
what he
this-
is, what he has said is that he will be flexible and nimble, and if necessary, he will reconvene this board to make a recommendation, and at that point in time, we would have a decision to make. This is fast-moving. I mean, just today, there's information came out at 4:03 this afternoon from the
What
CDC.
information came out at 4:03?
Pardon me?
What information came out with what I'm saying? I am at this point in time, right now, I am not ready to allow us to go back to where we were with the numbers that we have now. They are nowhere near where they were last year. So numbers are going up, but next week they could come down again. I'm not ready to mask our kids or do social distance or anything like that.
Nobody's
I also
asking
want
you to make those
remind-
decisions right now, Mrs. Rosario. He's only
Okay, well,
updating
I'm
us.
speaking and I'm giving my response to the superintendent. In my response, I am responding to the superintendent and I am letting him know where I am as a board member on this particular topic. We also have an executive order that our governor signed. The executive order trumps any recommendations by the CDC. The executive order states, and I'll say Executive Order 21-101, it states that, I'll just state the last part of it. It is with regard to COVID and emergency orders. We are no longer in a state of emergency, by the way. Not by the health department and not by the state of Florida. So let's take those into consideration. This executive order states that the governor of Florida, by virtue of the authority vested in him, I'm changing pronouns here, Section 1, in order to protect the rights and liberties of individuals in this state and to accelerate the state's recovery from the COVID-19 emergency, any emergency order issued by the political subdivision due to COVID-19 emergency, which restricts the rights of liberties of individuals and their businesses, is invalidated. Section 2, nothing herein prohibits a political subdivision of the state from enacting ordinances pursuant to regular enactment procedures to protect the health, safety, and welfare in its local population. Only the COVID-19 emergency orders as defined by SB 2006 enacted prior to July 1st, 2021 are hereby invalidated. So at this point, I would like for things to remain as is. And at a later time, we can have a further discussion about it. But right now, I do not see the need for us to move forward with limiting anything for our kids. People are already planning, teachers are already planning the new school year. We need to open as regular, as needed, as it is, sorry.
Okay.
Dr. Jones.
Thank you, Dr. Moore. Obviously, we've been all hearing the information from the CDC and watching this very carefully and receiving many emails, obviously, from parents. Are masks going to be required, encouraged, and so forth? And yes, I understand the governor's order. One thing that I think is important, that we can highly recommend masks. That's up to the parents, the students, and so forth, but there's nothing wrong with highly recommending that. And also vaccinations. We cannot mandate that, I understand, but we can also just share that we think that would be very, very helpful. A local health department now is putting out some information. It is 15.7 as far as the transmission rate and obviously the Delta variant. But it's just something that we can make our parents aware of, because we are hearing from parents now, or I am saying, okay, what if this spikes a little bit more? What do we do? Are we going to have the things in place? And what you said, I think, is important. The one-way traffic, no matter what, that's important. Making sure that we do the social distancing when possible, wearing masks when possible. Again, I know that's a choice, but we, as a school board or as a school board member, I can say it's very, very important. You know, one of the things we talk about, and I know Governor DeSantis had a talk with FSBA this morning, a roundtable, if you will. I don't have the complete transcripts from that, and I understand what he's saying right now, and our hands are tied with that, with the DOE and Governor DeSantis. But who knows? If things change, that could change. We don't know. But I just want to make sure the school board locally knows what is hitting us, I guess you could say, in Indian River County, as far as our hospital rate and everything else. I think this needs to be fluid. Again, we can highly encourage. We can ask for the social distancing when possible. We can encourage vaccines. Again, that's up to the parent, understood. But, you know, what also concerns me is, you know, I wish for a good year for you for some kind of normal. It's not going to happen, but even with our teachers and staff members, you know, going around, we'll lose instruction again. People start getting sick, but, you know, the most important thing for me as a board member is the safety of our students and staff and working together. We may not always agree on things, understood, but I do know we want our students safe and our staff members safe. I brought this up to you, Dr. Moore. I know we're not having a transitional because that executive order is done. We had the 3 models last year, but as we move into the year, and if it gets a little bit worse with the transmission, and the students want to sign up for virtual, will we be fluid in that, or what are you thinking there?
Through the chair, as of today's date, the number is still 0 families that have made the decision to enroll in virtual school. We did have a deadline of July 10th for that registration. To my knowledge, and I see Ms. Dampier shaking her head, we haven't had any additional requests to allow individuals in. But of course, as this, we continue to be flexible regardless of a tick or not. If that was a choice, you know that we are a pro-choice district, so if a family made the decision whether it was COVID or not, we would be flexible in meeting those individual needs of those particular students. And I just want to reiterate, this is a simple update to the board regarding where we are right now, not asking for approval or modifications to any specific things. You know, if you were to go back and listen to previous items, whether it was the handshaking, the hand washing, similar systems putting in place, maintaining the option to wear a mask, with the only variant saying it's highly recommended that you do wear a mask when social distancing isn't possible. So we're adhering to the desire of the Department of Education. We're not jeopardizing any of that. But we are allowing ourselves to be nimble. When I say nimble, you're right. There may be a shift in the direction, whether it be from the Department of Education, where we would have to reconvene the board. And that would be what I would do prior to the opening of schools or within the school year, if that need be the case, based on a drastic shift in reality.
And I thank you too, and I just want to make sure at our schools, and you can see I have a mask on for a couple reasons, and yes, I've been vaccinated, but I want to make sure that students absolutely have no issues if they're wearing masks. I just want to make sure that and I know the principals will work hard on that, please understand, I know how much they care about their students and the teachers, but that's very, very important because, you know, whether we want to admit it or not, this is a divide. This is a divide, and I want to make sure our kids are okay. Thank you.
And just to reinforce that, today we had a meeting with our principals and assistant principals at Storm Grove, and they were having their 6th grade orientation. And you saw not a lot of students wearing masks, but a few were with absolutely no issue. So I continue to be encouraged by the conversations parents are having, you know, with their children as we begin to allow students back into school as we prepare for the opening, and allowing and honoring choices families are making.
And I just hope and pray this Delta variant's one and then one and done and we can go on, but I just don't know the future. Thanks.
Mrs. Maddox, you had a comment from Mrs. Berenborg?
Yes, Mrs. Berenborg says she hasn't heard anything about our hospital bed situation, which was one of the major reasons we moved to mandatory masks. The ICU concern was part of our original decision, and she believes we should take all information into consideration before changing current policy.
Actually, as of this morning, out of Cleveland Clinic Indian River, 90% of the beds are occupied, and 2 individuals are on ventilators. The vast majority are unvaccinated people. 90% plus of the people that are sick were unvaccinated. Any other comments, questions?
I just want to thank Dr. Moore for bringing that to us. I know it's just a discussion, and if we need to have another meeting with updated information, but this is just something we have to stay on top of, so thank you.
Right, and just to be clear, the current practices remain in place. As I've listed them through, those were things that we would be doing as we would be entering school. You know, whether we're in a spike or not, it's just simple things we can put into place. The only shift, which is still allows the family to make the decision, is highly recommended when social distancing is impossible, which is still an option for families to decide.
Okay. Any other items for discussion?
Through the chair, that is all we have.
All right, before somebody comes up with a new one, meeting adjourned at 7:16. Thank you, Mrs. Rosario and Mrs. Barrenborg.